Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to go over something called a no complaint calendar. In California criminal court, a no complaint calendar, I've seen that used in a bunch of different counties, although I will kind of say at the beginning here, I don't think it's a universal term to every county in California. Probably not a term in all states either, but even within California, no complaint calendar, that term is not universally used. So I'm going to describe what a no complaint calendar is. And if you're in a county, for example, in California that doesn't use that term, leave me a comment down below about what term you guys use, if any, to kind of describe the basic idea that I'm describing. But especially if you're in another state or country, actually, and you have a similar type of thing as I'm about to describe, leave me a comment down below about what term you actually use if you don't use no complaint calendar. So I'm always interested, like I said, in other videos about how other states, other countries do, basically kind of handle the law, practically speaking, day to day. So no complaint calendar, what does that mean? So in California criminal court, a no complaint calendar might, I guess it predates the arraignment stage of a criminal case in California. So a while back, I put out a video about misdemeanor arraignments in California criminal court. So I'll try to link that video kind of up in the corner here, as well as down in the description, assuming that I can't figure this corner thing out real well. Check down in the description. So I guess probably the easiest way to do it or to explain it is chronologically. So let's say that you are out one day and you commit a crime of some kind, and you get arrested or you get caught by law enforcement. So you might be arrested, taken to jail, booked, fingerprinted, etc. Or it's possible that you just might be cited and released. So regardless of which of those options happens to you, there's generally going to be a point at which you get notice of your court date, of your first court date. So if you get cited and released by law enforcement, for example, hopefully that date is on that paperwork that you receive. Maybe you might get it in the mail at some point also. But if you get taken to jail and you spend the night there and you get let out the next day, for instance, hopefully they will give you some paperwork before you leave to say, hey, Mr. Smith, your first court date is August 1st, 2019, let's say. Please make sure you go, blah, blah. And a while back, I also put out another video that goes over like secrets about how to be successful in criminal court in California. Again, if I can figure it out, I'm going to try to link it up over here as well as paste it down below for you. One of the things that I mentioned in that video is in order to be successful in criminal court, in order to make it go as painlessly as possible, one easy thing to do that a lot of people don't do well is to basically show up whenever your court dates are scheduled. So if you get notice somehow, like in the mail, let's say, that you have a court date, 9 a.m. August 1st, 2019, make sure you go. Because if you don't go, you get a bench warrant out for you possibly, and that just makes things way more complicated. So, whatever court date you get, make sure you go. So let's say you go to court on whatever date you're told. One of two things can happen. So by that first court date, maybe the prosecutor or the district attorney, kind of in your county, has filed a court case against you already, and there's going to be charges, count 1, count 2, count 3, and so on. So if the charges have been filed against you, at that first court date, you might be arraigned on those charges. Again, take a look at that arraignment video that I have to go over what an arraignment involves and so forth. That's one possibility. If you don't have an attorney and you want to go hire your own, your arraignment rather might be continued for a period to allow you to go do that. So one possibility, like I said, is that the prosecutor has filed charges against you. You might be arraigned, if not that day, then at a later date, so that you can have your own lawyer present. That's option 1. Option 2. The prosecutor may not have filed charges against you by that first court date. You would think, I guess logically it seems to make sense that, okay, well, the court's not going to schedule a date for me until I have a case filed against me, for example. That logically, that would make sense. Unfortunately, that's not how it works, though. Generally speaking, the courts and the prosecuting agency, the district attorney, let's say, they generally don't cooperate kind of that closely, I guess. So the court date that you get when you're cited and released, when you are released from jail, let's say, that court date is set, and then that is not dependent on whether or not the prosecutor actually files charges against you by that date. A lot of times the prosecutor just doesn't get to it in terms of resources, personnel, etc. So by the first court date that is scheduled, the defendant shows up, and it turns out there's no case filed against him at that time. So that's what I mean when I say no complaint calendar. By the date of the by the first scheduled court date, normally that'd be an arraignment, but by the first scheduled court date, there is no case to arraign the defendant on because the prosecutor has not filed charges yet. So it's possible that the prosecutor might never file charges. My general rule of thumb, however, is that unless the time periods, which I'll describe in a second, unless those time periods have passed, generally assume that the prosecutor has not yet filed cases. In other words, they probably will at some point. Unless the time periods have passed, assume that the case, even though it hasn't happened yet, even though it hasn't been filed yet, the case will be filed at some later point. Well, I guess the other exception to this would be like if the prosecuting agency has explicitly told you in writing, we're not going to file a case against you because upon review we determine that the evidence is not very good and we're not going to file or something. Sometimes that happens, but until you get concrete proof one way or the other, don't read into the fact too much that, oh, just because they didn't file a case by the first court date, they're not going to file it. Don't do that, because that might happen, but most of the time it doesn't. If there's not a case filed against you by the first court date, generally speaking, that just means the prosecutor hasn't gotten to it yet and they'll file one later, let's say. So if they haven't filed a case against you like by the first court date, a lot of defendants will wonder, okay, how long do I have to wait? Do I just kind of hang around here on the edge of my seat forever? Like, what's the time limit? So the answer to this actually can be a little bit complicated, but the time limit that applies depends on the kinds of charges that you're facing. So the general rule of thumb for felonies in California is that the prosecuting attorney, the prosecuting agency, has up to 3 years from the date of the offense within which to file charges. So they have 3 years to file charges against you, felony charges. And if you want the authority for that, that's California Penal Code Section 801, which I'll write over here as well as link down below for you. But Penal Code Section 801 is the kind of most common time period that applies to felony charges. There are a lot of exceptions to that, however. So if you want to look at Penal Code Section, I want to say 799 to like 803, 804-ish, they go over a lot of exceptions to the 3-year rule. So if you have a case where the death penalty is on the table, there's no kind of time limit for that. If there is a life imprisonment kind of thing, if life imprisonment rather is a potential sentence, there's no time limit for that either. For whatever reason, child pornography is kind of carved out as a special kind of exception. That's 10 years from the 10 years from the date of production of the pornographic materials. There's certain kind of statutes, I guess, that apply to like failure to register as a sex offender. Let's say I think that's 10 years. Typically, if not longer, via some other statute section, for instance. So 3 years for a felony charge is kind of what's most common, but it is not the only time limit by any means. It depends on the charges that you're facing, the particular code sections and so forth. So so 3 years rule of thumb for felonies, but a lot of exceptions apply also. So for misdemeanors, which I think probably applies to more people in California, for misdemeanors, the general rule is 1 year from the date of offense. That's Penal Code Section 802A in California, which again, I'll write over here and then link down below too. But Penal Code Section 802A says 1 year. However, again, there's a bunch of exceptions that apply to this also. So for example, I think it's annoying or molesting a minor child, I think that misdemeanor charge has a statute of limitations of 3 years within which to file a charge. Let's see what else. Sexual assault by a physician, counselor, doctor against a patient, that I think is 2 years. And the only other thing that pops to mind, honestly, right now is if you're a contractor in California, like if you're licensed as a construction contractor by the Contractor State Licensing Board, a lot of the rules that apply to you that says, hey, you have to do this, you can't do this, etc. A lot of those rules that if you don't follow them, they're actually misdemeanors. Those statute of limitations, I believe they're like 1 to 4 years. Some of them are up to 4 years. So the prosecutor has up to 4 years within which to charge you for those types of things. Practically speaking, will they wait 4 years? Maybe, maybe not. Yeah, it completely depends, on the prosecutor's kind of discretion about whether or not they will wait the full 4 years, for example. But the point of the statute, however, is that they can wait the full 4 years if they want to. So hopefully that helps kind of make sense. A couple topics that we went over in this video. Number one is that the no complaint calendar is a possible kind of outcome for you if you're a defendant and you go to court on your first scheduled court date and you find that there's no case against you at that point. There might be, in which case you go forward with arraignment typically, but it might be something where you go to court on the first court date, you show up on time, and it turns out there's no case against you. If that happens, possibly the DA tells you, hey, we're not going to file charges, you're free to go, etc. That would be the best outcome for you, I think. But realistically, a lot of times the prosecutor just hasn't gotten to filing a case against you yet. For felonies, they have up to 3 years, typically, from the date of offense. A bunch of other exceptions also, but 3 years is what's most common. But if you're facing misdemeanor charges, the most common time period that applies is 1 year from the date of offense. But again, there are exceptions to that too. Sometimes it's 3 years, sometimes it's 2, sometimes it's 4. So the best way to kind of figure out what applies in your situation, obviously, is to find a lawyer, go over the facts of your case, kind of in specific detail. So again, hopefully all that helps. Go ahead and watch this video again, share it, comment, like, subscribe, etc. And I will talk to you guys next time. Thanks.